Okay, we are live. Awesome. Well, welcome everybody. Thank you so much for joining us. My name is Paulina Hurtado. I am the broker owner of Century 21 Global Connections Realty. I am very happy to be back. For those of you that don't know, I broke my ankle 2 weeks ago in a lot of different places. So we had to do a little bit of modification for the office. And you can't see my ankle, but it's on the other side of the screen. And I am here with my amazing friend and attorney, Robert Shearin. Thank you so much, Robert, for joining us. I just want to let you guys know a little bit about him. Prior to entering law school in 1992, Robert was the vice president of sales for a public trading company who dealt with various lawyers. He thought most lawyers did not understand their customers or their particular business, so he decided to become a lawyer himself. He graduated in top 5 of his class in St. Thomas University of Miami. He clerked for Judge David at the District Court of Appeals and studied all types of law. After clerking for the judge, Robert opened his law office and handled civil and criminal litigation, and in addition, representing various corporations in all aspects. He understands the various types of entities to create a status of all types to protect assets and avoid expensive probate proceedings. He's licensed both in Florida, state court, and the federal courts in Southern and Middle Florida. He has been practicing for 25 years. Welcome, Robert.
Thank you.
So we are here today because I felt the need that a lot of people don't understand, that they need to protect their assets. And, you know, I've been doing real estate for the past 15 years, and I was blessed enough to meet Robert right at the beginning of my career 15 years ago. And just talking to him, and actually I met him because of a client, and talking to him, he explained to me why it was very important to do a living trust and to do, you know, to make sure that at that state of my game, I was not married and I didn't have kids. So to make sure that, you know, everything that I had would go to my parents. Of course, we've made a lot of amendments through the years as I got married, and then now I have kids. But, you know, I just want to go over a couple of things, Robert. Tell us a little bit about what is the different types of ways that people can protect their assets. I know that there's the living trust. I know that there's land trust. I know that there's corporations. I know that, you know, the main goal is to avoid probate. So tell me a little bit about that.
Okay. Most common that you see is called a revocable living trust. Okay. It really doesn't protect your assets. The purpose of a revocable living trust is to avoid probate when you pass away. And what that does is, for example, if you die, there are 2 ways to go about distributing whatever you own at that time. One is by your will. The other is the state decides. So if you die without a will, the state's going to decide where your assets go. And the state can change that at any time. So it's always, you need a will. Everybody needs a will. The problem with the will is, regardless of how you leave your property, when you die, you then have to go to probate and bring the will in, and then you have to publish it. You have to do all the things, pay the creditors. And it's a series of how your assets will be distributed. Your medical expenses, your funeral expenses, and then your debts, and then they go to your heirs. Well, you can, and probate, a simple will, you know, lawyers charge all different things for simple wills, but typically you're talking roughly a couple $100, $200 to $300, probably most people can do a simple will. The problem with that is when you die, then somebody's going to have an expensive probate proceeding. You got to have, the personal representative has to have a lawyer, and you can, just a simple probate will cost you $2,000 or $3,000. Or if you do a revocable living trust and you put all your assets into the trust, when you die, your trustee then distributes your assets according to what you have decided, and you don't even have to go to court. The caveat or the warning for that is you make sure you put them into the trust, because if you don't put them into the trust, then you still got to go to the probate court. The probate court will then put them into the trust. a revocable living trust, the beauty of it is, it doesn't matter how old you are or anything, is that you can be both the trustee and the grantor, all right? And at any time, just like Paulina, you mentioned, you came to me, we did a revocable living trust for you before you were even married. You know, we've amended it, I think, a couple of times now. We just added the new child to it. And she controls everything. And whatever, anytime she can amend it. You know, if, just for example, she doesn't want it for one of her children to inherit anything, she can take them right out of it with a simple amendment. And it doesn't have to go to court or anything like that. The thing about probate law and all that is you can disinherit children, you can't disinherit your spouse. In Florida, the spouse has what's called an elective share. They can elect to receive 30% of your estate, regardless of whether you want to leave them a penny or not. And then it can waive that. But the revocable living trust is you're the trustee, and in that document, you control everything. And
So
then when
let me interrupt you really quick. So if I do a revocable living trust and I don't want to leave anything to my husband, he still has the right to that, or because I
yes,
did the revocable living trust, he doesn't?
no, he can
So with
still,
the
you
he still
cannot
has it,
disinherit you. Yeah, there's
but
no
I
way.
can disinherit my children. Like I could be like, I'm
Oh
not
yeah,
leaving anything to my kids.
yeah.
Okay.
And they'll challenge you, of course, usually, but you know, regardless, you can do it. But so that's kind of a nutshell of what a revocable, it's basically to avoid probate. Now you can do an irrevocable trust. An irrevocable trust is you then put into the trust whatever you want to, and you can't change that without somebody going to court for you. The beauty of an irrevocable trust is that it used to be a good tool to avoid estate tax. Estate tax can be very, very expensive, especially when you have a large of estate. And it used to be you had an exemption of a couple $1 million, and then it went to $5 million, and then I think it got up to about $11 million. That, you know, anything below $11 million, you didn't have to pay estate tax. Anything above it, it was almost like 50% you had to pay. President Trump has eliminated the inheritance tax, called the death tax.
So now
But it
we
could
don't
come
have to
back
pay
to,
anything if we inherit anything.
no, not
What?
anymore. But that can
Okay.
change. Congress can change that. You know,
Right.
they've changed it over the past 30 years. Like I say, when I first started practicing law, I believe the exemption was $600,000 each. So anybody had over a million, 1.2 million as a husband and wife, it was subject to the inheritance tax. A good example of that is most people are familiar with Joe Robbie. He owned the Miami Dolphins. And he bought the Dolphins. He only probably had $1 million, $2 million that he put into it because he started it right off as a franchise. When he died, the Dolphins were worth hundreds of millions of dollars. And the reason it went from the Robbie family to the Huizenga family, they didn't have the monies to pay the inheritance taxes. So they had to sell the Dolphins, and part of the proceeds of their sale went to pay inheritance taxes. That is not the case anymore. But like I say, that's gone from, you know, $600,000. I've seen it at $2 million. I've seen it $5 million. I think it finally got up to $11 million you had a credit for. And then now Congress through President Trump that's done away with the estate tax. But that would be the purpose of an irrevocable trust. The problem with the irrevocable trust, you put it in there and you don't have control over it anymore. You can live off the proceeds of it or the income coming off of it. So it's really not, I don't like that tool. Irrevocable trust, though, totally protects your assets. Creditors cannot go after irrevocable trust. They can go after the proceeds you get out of it, but they cannot. So if somebody really wants to protect their assets, an irrevocable trust is the best way to do that. Now,
But
properties,
with the revocable living trust, the creditors can go after that?
yes, yeah,
Okay.
yeah. You know, it does not protect. The purpose of a revocable living trust is strictly to avoid probate. It will not avoid your creditors. Now, people that purchase property, and I run into a lot of this, and you've had clients that come to me, and especially if it's not their residence, if it's rental properties or investment properties, they really need to protect their other assets from that property. Okay. What happens is, let's say I buy a property and I want to invest, it's for investment purposes. And somebody comes onto that property and gets hurt and I didn't have insurance. They can not only get my asset of that property, they can get all my other assets because I own it individually. What I've recommended that people do when they buy investment property or rental property is two ways to do it. One is to put it in a limited liability company or an S corporation. And then if something happens, you're limited your exposure to just that property. They couldn't get anything else on it. You could even put a mortgage on it, and that even limits what they could get out of it anyway, because that's the only asset that's in that LLC or that corporation. Another tool that I find much more valuable is called a land trust. And to me, the land trust is really a great way to go, because if you've got an LLC or an S chapter corporation, every year you got to pay a $150 filing fee for the state of Florida. You have to have a tax return. Or if you put in a land trust, you don't have to register with the state of Florida. And the only thing that's shown on the property records is your land trust, like 123 Main Street Land Trust. And in that land trust, the only thing in there is that one property. There, and benefit, you can be the grantor, you can have beneficiaries, whatever, and nobody can go after the grantor or the beneficiary. The lawsuit can only be against the trust itself and not to the trustees or the beneficiaries. So you really limit your exposure for any of your other assets, and the only exposure is for the land itself. So that in a nutshell is kind of and going back to revocable living trust to avoid probate. What you do as a package is you not only put it in trust, you do what's called a will also, and it's called a pour over will, P-O-U-R. And that means if you didn't put it in the trust, whatever you do have pours over into the trust. And in other estate planning documents is, a healthcare surrogate, a power of attorney, a living will. These types of items, help you while you're living, and somebody else can make decisions for you when you're not able to. A power of attorney, I strongly recommend not to have one. The power of attorney is a powerful tool. And whoever you give that to, they can sell your properties, they can take every money out of your bank account. The only reason for it is when you get advanced in age. Like my mother is 96 years old. And I guess it was about 10 years ago, I gave my younger brother the power of attorney over her. But up until that time, I didn't, even though I had her in a revocable living trust and all the estate documents she needed. I didn't think it was to her benefit for anybody to have the power of attorney. But you can give it, the power of attorney is good for people that you truly trust, the child is taking care of you and things like that. But you really don't need that until you get advanced in ages.
Now, okay. So one of the things that I did like about the revocable living trust when we did it is that, like you said, it doesn't only cover, the fact that, we're going to avoid going to probate, but it also covers, like you said, if God forbid, I'm plugged into a machine and, I'm on life support, it avoids my husband and my family making that decision because I've already made that decision then.
That's not in the trust. That's it. That's in the healthcare surrogate in the living will. Separate document.
In the living will. Okay.
The package. Exactly.
Okay. But it's the whole package, right?
Exactly.
It comes in the whole package.
Right.
And then in that package, we also have, God forbid something happens to Leo and I, what would happen with Isabella and Alexandra, which is our dog.
And that's in the trust agreement. Yes.
Yeah.
And that because what you do is you appoint a guardian of the person, the child, and you can also appoint a guardian of the property. Like I have clients that they'll have a relative that will be responsible for the person, but they'll have another person that's responsible for the property, the assets of the trust, because they're better suited. It might be a financial advisor, they know, an accountant, anything like that, where the relative, doesn't have the expertise to invest the funds or anything. They're just taking care of the person. And you put in your trust, like, that the child doesn't get the benefits of the assets until they reach certain ages, 25, 30, 35, whatever you decide. It's a very useful instrument to use both for, when you're gone and for the best protection of what you're leaving your children or whoever you're leaving it to.
Now, one of the questions I'm actually asked a question here live right now. They're asking, what age would you recommend for a power of attorney to give a power of attorney out? I guess you said that you don't recommend to give a power of attorney unless it's 100% absolutely necessary.
Yeah, there's two criteria I would look at, and this is from me. This is nothing legal. This is just a personal type thing. I've had people that have had power attorneys with people when they're 30 or 40 years old. And, they truly trust whoever they're giving it to. Husband and wives, you see that a lot at different ages. But really, the power of attorney is you need to get advanced in age, in my opinion, or your health starts deteriorating. Your health can start deteriorating at 40 or 50 years old, just as well as it can at 80 or 90. But the problem is you can't wait too long. You don't want to wait. Like today, my mother's 96. She could probably still sign a power of attorney because she still is in the right mind. She's failing, but she's okay. But most people at 96 might not have the capacity to execute a document of power of attorney. Now you got a problem. Now you have to go to court to get a guardian, and that can be expensive. So the power of attorney, you really got to watch someone's health or yourself. And a lot of times it's children that look at their parents, like I did with my mom. Because, when she reached about 85, I thought it was time that, one of us needed to have some power of attorney to do things. The power of attorney is controlling your assets. The medical power of attorney or a healthcare surrogate, that's just for your health benefits. Everybody needs that. I don't care if you're 25 years old or 85 years old.
Okay.
Because you're involved in an accident and you can't make a decision. You need to have somebody, your siblings or somebody that's close to you, and you've got the exact instructions. Because like I have my healthcare surrogate. My wife is my healthcare surrogate, is that she knows that I'm not to go on life support. That's not what I want. That's not my wishes. You give me a little water. You don't need to feed me. If you want to give me some pain medication, that's fine, but nothing else. Do not don't put me on life support systems. I mean, my cousin, the same age as I am, I'm 70 years of age. He died 2 weeks ago.
Oh my God, I'm so sorry, Robert.
Yeah, no, I'm not. I feel blessed because 14 years ago, he was putting gas into his car and he passed out and he had a blood clot in his brain. He has not spoken a word for 14 years.
Oh, wow.
He has not, he's had to be, his wife is a registered nurse, but he had no healthcare surrogate, a living will, and he was on life support for 3 months. And they took him off of it finally, and he lived for 14 years. I could not even see him. He was one of my closest friends all my life. And it's a terrible thing where I know he would not have wanted that, but
right.
he didn't have the document telling what he wanted done. And it was some kind, the wife wanted one thing, the mother wanted one thing. So it's that type of thing. And the doctors and all, they can't take you off life support unless they have somebody that has the authority to do that.
Well, even when I had my surgery 2 weeks ago, I guess now the hospital make you sign something that says who's going to be in charge of what happens to you if, God forbid, you don't wake up, and I know this is a sore subject for everybody because everybody tries to avoid this as if it's never going to happen. And, things happen in a matter of seconds. I mean, 2 weeks ago when I was on my way to the office and then I stepped down from the garage, from my laundry room to the garage, and I broke my ankle in a million pieces. And, my life turned completely because it changed. My biggest fear during COVID-19 was not to get COVID-19, but actually for one of my family members or myself to end up in the hospital because you're going to be by yourself. That's the
worst place to be right now.
And you're going to be by yourself. Your husband is not going to be able to visit you. Your parents. Right. I mean, nobody. And at that moment, my biggest fear became a reality. The 911 came. They picked me up. And they told my husband, you can't go to the hospital, so don't even bother getting in your car because they're not going to let you in.
Right.
So I
Terrible.
think that a lot of people avoid this conversation because they think things are not going to happen because, you know,
Right. The
they
cousin
look
I'm
as
talking about, he was
older.
56 years old, 56 years
Imagine.
old. He had no
So,
idea that that was going to happen to him.
so he had to live 15 years in life support to be, you know, that, and like you said, most people don't want that. I mean, my husband
No.
knows that I don't want that.
Right.
So, you
But the
know,
document you signed at the hospital that they asked, that's only given a person to make your decision. That person doesn't know what your decision is always.
right.
See, the healthcare surrogate instructs him or her on what you want,
Yeah.
you
And
know,
I
and
mean,
that's the key.
we did when you and I met, I think I was 21 years old, you know, when we did it, right?
It's been a
Now I'm
while.
36, right, Robert? But, you know, and I remember when you told me that and I was like, "Oh my God, I don't want to have my parents go through that." And then, you know, when Leo and I got married, which you were through that, I was like, I don't, you know, we don't want our, you know, I don't want my significant other, and then the kids came, and I'm just blessed that I met you at such a young
Right,
age and you explained to me the importance of not leaving that burden to my family.
right.
So
It's
you know, I
terrible.
have another question in here. It says, so you recommend to declare a healthcare surrogate instead of having a POA?
Yeah, the healthcare surrogate is a power of attorney on your medical. I recommend everybody have a healthcare surrogate. I have one document called a healthcare surrogate and a living will. The living will is it instructs people what you can do while you're still living, but you're not able to make your decisions. And you appoint somebody to do that. And, you know, it should be somebody you trust. The power of attorney also has that provision. You don't need, if you have a power of attorney, you really don't need a healthcare surrogate because you've entrusted this person to make the decisions for you. The power of attorney goes one step further, though. It gives them control over everything you have. The only thing the power of attorney doesn't do, they can't vote for you, and they can't change your wills or your trust or any type of testament. So that the power of attorney, though, is if they can go to your bank account, take everything out of it, they can sell your house, they can do anything. They can do it. They're acting on the power of attorney, though, does end when you die. Okay. So don't think, a lot of people, they give a power of attorney to somebody and they think that, okay, I don't need a trust, I don't need a will or anything, they're going to take care of everything. That power of attorney, though, that stops the day you die.
Okay.
So if you've got somebody as a power of attorney over your bank accounts and your land, when you die, they can't go to your bank account and get that money out.
Okay.
And there's certain ways to protect bank accounts also, and you can avoid probate if you don't have a trust. And that is you put them, the bank will allow you to have a beneficiary of that account when you die.
So you recommend that if you're not gonna do, well, we always recommend for you to do either a living trust or a land trust or any of the forms that we're speaking about. But
Right.
if you at least if you don't do any of that, at least go to the bank and tell them that you want to put a beneficiary in there in case
Right.
something happens.
Because here's the issues, and this is what everybody needs to understand. All right. Is that, let's just say my household furnishings, my couches, my everything in my house. I can write you out a list of who I want to have that. Might not be valid or whatever, but you don't need to go to probate. All right. Why you have to go to court is to transfer anything that's in a bank, anything that's real property, stocks and bonds, things of this nature. They're the things that you got to go to probate because the title changes. All right. So if you don't own real property, like I had someone ask me a while ago, should I do a trust or a simple will? And I said, you do a simple will because you don't have any property. You know, all you have is a bank account. So therefore, just take the bank account and put someone that, put whoever you want to leave it to, put their name on it. And then when you go, they can go in and do it. They can't do anything prior to that, because it's being held in trust for is what it's called. The bank has a title for that. But the real property in stocks and bonds and bank accounts, that's what you need the revocable trust for, because then the trustee will abide by your wishes. Now, people have asked me, said, well, what if the trustee doesn't do what I asked them to do? Well, that's a problem. That's why they're called trustees. It's somebody you trust. And I've known, I've been in lawsuits. An elderly lady made, a distant relative, the trustee, and they stole every bit of her money. and didn't do it the way that she wanted to.
Oh my God.
There's a lawsuit, and even criminal. It can be criminally charged because they have breached a fiduciary duty. It's actually stealing the money. So typically, your beneficiaries in a trust are not just one person, other than a husband and wife a lot of times. But you've got some children, you got relatives, you got 2 or 3 or whatever it is. And one of those typically is the trustee. The others will hold them accountable for. I've got clients that have nominated me as their trustee, and others will take their professional trustees, banks, financial institutions. A lot of them act as trustees. The difference there is they're going to charge you. Where if it's one of your children or a relative or something, you don't have to pay the trustee. He'll just disperse it according to your wishes.
Now, let me ask you, Robert, because somebody asked me a question. What is a life state? What's the difference between the life state and everything else that we have been speaking about?
All right. Property can be owned in a variety of ways, okay? It can be owned in a corporate name. It can be owned in a land trust, an LLC, a corporation, a land trust, individually. And then there's a concept that's owned by husband and wife. That's a legal fiction, is what it's called. A husband and wife is called tenants by the entirety. All right. It's a great concept. And what that means is a husband and wife are one. All right. So let's just say somebody gets a judgment against you, Pauline. All right. And you and Leo own your house as tenants by the entirety. They cannot go out. Number one is they can't go after your homestead anyway, but they can't go after property unless they get a judgment against both of you, because you and Leo are one as tenants by the entirety. And any properties husband and wife own, I always try to encourage them to own that as tenants in the entirety. The other thing you can own property at is called joint tenants, and that can be 50-50, it can be 20-80. You put it right into the deed. 33% owned by her, so and so, 33% by this and that. And you can have one joint tenant, you can have 10. I have land in North Carolina that my family has owned for many years, and it was four of us, 4 brothers, and we own that as tenants in common. All right, and we each own 25% of it, and it looks like it's joint tenants. The house my mother lives in also encompasses 55 acres of land. It's a difference from where the farm was. Now, that's where the 4 of us have what's called a remainder interest. And I transferred that to us from when my father died 25 years ago. What I did is my mother has a life estate in the home, okay? So what a life estate is that the person that is going to be living in the property or owning the property or controlling the property while she lives or he lives, it's called a life estate. And in the deed, it has who's the remainders, like the 4 of us, my brothers. Or you can put anybody, they have a remainder interest. What that also means is that it's the life estate. Now, the person who owns a life estate can sell that life estate, okay? Let's say I have a life estate on a piece of property, and I go to you and I say, Pauline, I'll sell you my life estate. You say, great. And let's just say John Doe has the remainder interest, right? You think, okay, well, the life estate, you're going to live, you might think Pauline, you're going to live 40, 50 more years. I can use this property 40, 50 years. The problem is the life estate's on me. So you're buying my life estate. I'm not going to live as long as you. The life estate doesn't transfer to somebody I sell it to. It's okay. My life estate is based on my life.
Right.
The remainder interest really has the value. The life
so for example, to put it, I guess, in more plain thing, let's say I put my property, my homestead property under a life estate. So when I die, like let's say I put that life estate and I put my daughter's names, would that go to my daughters?
Yes.
Okay.
100%. Yeah.
So can you do that with any property, or is that just the homestead property, or you can do that with any property? Now, I have another life question here. Can children be put as beneficiaries? If so, is it still go to the courts until they are legal of age?
No. No, you can take care of everything right in the trust. Like I believe, I'm not.
But they don't. They cannot use that money until you put the age that they can use it. Correct?
No, what it would be, let's just say you have, a 10-year-old child
Let's
and
say
you die.
Isabella and Alexandra. Let's use,
Right,
them two. That like she's 3 and the other one is 1.5.
right. Okay.
Okay.
All right. You and Leo pass away. All right.
Yeah.
In your trust, all right, until they're the age of 18, the guardians that you have appointed in your trust, all right, and we have explicit guidelines of what they can do. They can use any of the monies in the trust for their health, education, and welfare. And many times I've had people say, okay, I want them when they turn 16 or 18, I want them to have a car, okay? Because if you give an 18-year-old, I don't care who it is, the most responsible child in the world, you give an 18-year-old monies and the first thing they're gonna do is go buy a car. That's the worst thing they can buy. They need to be on property that's going to appreciate. Cars depreciate. And they're gonna buy one, some stupid sports car, and it's ridiculous. So I put into it that they can buy equivalent of a Honda or Accord, Honda Accord or Honda Civic or a Toyota, whatever, whatever the individual wants. And you dictate to the successor trustee exactly what they should be giving your children. So you're still kind of monitoring and being responsible to your child, even in your death. And the trust gives them explicit guidelines of what they can do with the monies and what they want, for their education. I put in that once they can put down up to 20% of their assets for a deposit onto a home, So it's those, and
So you can,
right
it would be very specific. Like you could
Yes.
tell them, okay, what you can use
Right.
the money.
And-
Now,
and
what
don't-
happens if there's another question. Let's say right now somebody doesn't have anything. They don't have the living trust. They don't have anything. The only thing that they did is in their bank account, they put their daughter, who's 5 years old, as the beneficiary.
Oh, gee,
Then
that's a problem.
what happens? The daughter can use that money or no?
No, the daughter's not even 18. It has no, daughter can't even sign a, I don't know what they would do. You wouldn't put your beneficiary of a 5-year-old on a bank account.
Right, because they wouldn't be able to use the money, right? Because
No,
they
I
still
don't
would
know what
have to go to court.
Yeah, I don't know what would happen.
Right.
That's a good question. I've never known anybody do that. I've seen them put the children, but the children were always adults. I've never known anyone to put a beneficiary on a bank account or be held in trust for. Other than there's child custodian accounts where you have the account and you're holding it.
Yeah. Like I have for my daughters where, I just put money in there until they
Exactly,
grow
for
up.
their
And,
education fund or whatever.
Yeah.
Right. But they wouldn't have access to it, and the bank wouldn't know what to do with it. The court would have to decide who had control over it until they were adults.
okay. So let's just say, God forbid, I didn't have anything, because I'm going to use me because, we've already done that. But let's just say Leo and I didn't have anything. We don't have a will. We don't have a living trust. We don't have absolutely anything. And tomorrow, God forbid, we both pass away. What happens to my children first?
They could very easily become wards of the state.
Okay, so let's say, they have grandparents. So the state would first take them out, and then they would decide who they would go to.
The children and families, probably what would happen is your parents would come in, they would take the children, and then they would petition the court to get, full custody of them. They probably wouldn't. When you've got family around like that, children and family services first is going to look to the family. They don't need any more children in.
Unless there's a custody battle. Like let's say Leo's mom and my dad decide to get into a custody battle.
Oh, yeah.
And then now the state has to get involved. They'll take the children until they decide who's going to get custody.
It would probably be something that would be done fairly quickly in that matter. That Children and Family Services would bring it to a dependency court to make a temporary ruling anyway, so that children wouldn't have to go into a strange home. Because if you've got two people that have good home, and they thought they were good homes, they would try to come to some resolution depending on a final determination. That would be the best case. If you got children, you really need something in writing about,
and that's not just a handwritten piece of paper, right? That says that
you need well, it could be handwritten and everything. You just need 2 witnesses and a notary.
Okay.
The notary cannot be one of the witnesses. That's all it takes in the state of Florida in most states. So anything done in Florida would transfer to other states. Some states only require a notary. Some states only require witnesses and no notary. So every state's a little different on that.
So
But
Florida is 2 witness and a
two
notary.
witness plus a notary.
So it could be just a letter that says, I want to leave my children to my dad, and then I just have 2 witnesses and a notary.
Right.
Okay.
Yep. Yeah.
And
you
then,
don't need a, you don't need, I did a probate proceeding up in Orange County in Orlando. And the lady hand wrote, I mean, it was very difficult to read the will. The whole thing is, now this has been going on for 18 months to give you a good idea.
wow.
She owned the homestead. Her husband was still living, which that was held outside. Did a petition to determine homestead. They had a sale for the property, and it was supposed to close, and she died 2 weeks before the closing, and she owned the property in her name alone. But she had was left to her the half interest by her grandfather in a Burger King in Chicago. And we just finalized that Chicago proceeding because she left all her estate to her 3 children. Her husband was not the father of the 3 children. And she left the income from the Burger King to her husband until he died. There's no such entity in the state of Florida or in the state of Illinois. You can leave, that's a life estate, but she didn't leave a life estate to him. She left an income interest.
Wow.
Because the Burger King, they didn't own the Burger King, they owned the property the Burger King was in. Burger King was paying them a monthly thing. So he was getting half of that because her sister owned the other half. So he was getting a half of that income. The Burger King left 7 months ago. So what's the income interest?
There's no.
The courts didn't know. But she hand wrote this out where, and I don't know why she didn't. Her son or her son-in-law had been a long time client of mine, and why all she had was simple trust. They have spent right now probably about $10,000 in attorneys.
That's what I was gonna ask you. So if I don't have anything, right? Like that's what I was talking about. If I didn't leave anything, and even like, let's say, you know, the custody that the court has to go, what does that cost? Like, let's just say that I did leave a piece of paper that was signed and notarized. What's the cost for that? Like for me to go and make sure that the court enforces that.
Right. The problem is it's hard to say. All right. What the state of Florida allows, it allows an attorney to get 3% of the total estate. They can charge that plus their hourly rate. Now that doesn't mean I don't do that.
I know.
I charge for what I do, my work.
I know.
The problem is that with the probate, is a good example is this lady had a trust, revocable living trust, left her 2 sons as co-trustees and everything. She owned a house, had all that, and she put it, and they put it into the trust. But her grandfather left her 100 shares of stock in Philadelphia Electric. She didn't put it into the trust. Philadelphia Electric, she had 200 shares of stock originally. Long story short, Philadelphia Electric turned into 7 different companies. The other was a company called AT&T that had been divided into 14 different bail houses. She had 20 different stocks off of those 2. They were worth about $425,000. And I had to open the stupid probate to get all those stocks transferred. And it meant I had to notify all the creditors. I had to do all this. You know, it cost them around $5,000. And all she had to do was just send in this one little piece of paper to the stock holding company, and it would all been done. So if you don't put it in there, the cheapest probate that you can do, called a summary proceeding, because your homestead is held outside probate.
Right.
Petition to determine homestead, but you still have to go to the court to get that. You can sell the homestead. A summary proceeding, about the lowest you can get by with is about $1,500, $2,000. Most, I mean, I would love to tell people that, for $2,000 or $3,000, you can go through probate and get it done. I mean, I've seen them for, I mean, a good friend of mine does a lot of probate litigation. He just finished one, and the client I referred to him, it was $124,000 they paid.
For probate?
And they didn't even go.
Oh my God.
And the reason I didn't wrap it, I did the trust for the lady, and she cut out her son on the will, and she was explicit, and he said, oh, she was being influenced, and she wasn't. I had two attorneys in there with me, witness and everything.
Well, I don't know if you
that was just one side. The other side probably paid the same thing.
I don't know if you remember this, Robert, but I had a client of mine during the whole, when the market crashed or whatever, that, she was the only sister, and the sister passed away. She didn't have anything, didn't do any will, didn't do absolutely anything. And she needed to start probate so that the apartment would be given to the sister. Well, in order for her to start probate, it was like $5,000 or something like that. And the apartment went into foreclosure.
Right.
And she lost the equity of the apartment because her sister never left anything like that. So I have two more questions here.
Sure.
Arelis is asking, who will enforce the trust?
The courts.
The courts enforce.
One of the, let's say if you had 5 beneficiaries of the trust and the trustee cut one of them out, that beneficiary would, file a complaint in court.
And does that cost anything?
Yeah. The attorney, yeah. But you get those fees back from the trustee if you had anything, if you hadn't stolen everything.
Okay. But if the trustee does what they're supposed to do, then you don't have to you don't have to go to court. Okay. And then the other question is, let's just say somebody leaves a piece of paper that says what's going to happen to their children with 2 notaries. I'm sorry, notarized and 2 witnesses, and the notary cannot be the witness. Where would they leave that paper? With a person, or somebody needs to know where that paper is, right?
Yeah. And you need, like, just with the will too, you need the original documents.
Yeah, even with the living trust, you need the original documents. You've told me that.
Right. It's not so much with the trust, believe it or not. Like title companies and all that, they'll accept the copies of the trust. Courts, like the will, they want the original of the will. You need the original. And the reason for that is that, if you've got a copy, the person could have disavowed that will and tore it up, and you got a copy, you don't have the original. So, you really need the original. I tell people the one thing you got to watch with, and this gets a little tricky. A lot of people have safe deposit boxes, and they put their will in there, right? If you put your will and your trust and your important documents in there, just make sure that the person you're giving has access to that box. Because if they don't, guess what you got to do to get access?
You got to go to court.
You got to go to court, get an order to get into the safe deposit.
You know what? It's a good thing that you told me that, because my parents have their living trust in the safety deposit box in the bank.
Right. And you need to have access to that.
Okay.
They need to have you on that signature. What I tell people is get your own little safe that's fireproof, because nobody's going to steal your documents, and keep your, these original documents in that, and just let your whoever you're going to have as your successor trustee, and within a will as a personal representative, let them know where it is. And I also tell people when I make these documents, I draft them and then we execute them. I give them a couple copies of everything. And I say, whoever the successor trustee is, send them a copy so they know what your intentions are.
Okay, so I have another question. And these are typed in Spanish, so bear with me if I'll translate them. It says, what are my options to avoid what we talked about, an inheritance tax? I am from out of the country, and I bought 2 apartments. I don't have a corporation, and I don't feel like there's a necessity for me to have a corporation because I would have to pay too many expenses to the accountant. What kind of document or do you recommend for me to do? So a couple of questions. First,
First off, he doesn't have to worry about the inheritance taxes.
Yes, because of what you told
Two
us now.
apartments, unless even on the ocean, you're only talking a couple $1 million, and they're never going to be below that without having a credit. So he doesn't have to worry about inheritance taxes.
Okay.
When it's sold, he's got to worry about, the income taxes or the capital gains taxes.
Right.
But I would tell him that he should put each of them in a land trust. I really would, because his problem is especially if he's renting these apartments, is that if one slips and falls, hurts themselves, it doesn't matter if you got insurance or not. Sometimes you just can't have enough. Today, with the litigious society we're in, these juries can go run away, and he could lose both properties because of one. By putting them into a land trust, he doesn't have any, he just has to have a tax. He's got to do a tax return anyway if he's renting, because it's rental income. Okay. But with a land trust, he just, it's probably going to cost him maybe $100, $200 more a year to file another tax return. But for the peace of mind, I would have them separated somehow. And the other way you could do it
and
is.
What does that cost? Because I think a lot of people have the misconception that doing a living will.
The only cost of a land trust, I do a land trust with everything included, and you have to deed it. You have to quitclaim deed it into the trust. It's $600, and then each year is the recurring cost of the tax return.
Yeah, but that's not
cost.
Yeah, because I know that with my parents, that's what we did. We put the property under the land trust, but they avoid the expense of the accountant for the corporation. Because the expense they have to pay with the corporation, they have to pay to renew the corporation every year. And even with the accountant, to do corporate taxes is more expensive than for them to put the land trust under their personal tax returns.
Right.
So they actually avoid, so the land trust, I would think it would be the best recommendation, like you said.
Most attorneys won't do that. Most attorneys, you'll find very few attorneys that do land trust. And I do not understand why. I researched it thoroughly.
I remember.
It's a great tool because you protect the beneficiary and the trustee. You can't go after either one of them. You can only go after the land that's in the trust. You cannot touch the trustee. You cannot touch the beneficiary. And the other great thing about it, and the reason that they don't like it, is title companies don't like land trust. But I don't care what a title company likes. It's a trustee's deed. And it's not a big deal, but they're like, well, I got to, to write the title insurance, I got to make sure it's original. I got to check who the beneficiary is. So you got to do 5 more minutes worth of work, So that's what you get out there, is because a lot of people that do the land trust also do title work. And I don't do title work, so I don't care about the title work.
I know. Okay, so then I have another question, and again, these are in Spanish. I have a corporation where me and my wife are in the corporation. Under this corporation, we have a couple of apartments. What is the best route for me to take this in order to protect my kids? In case I pass away.
Okay, the land trust is by far the best because right in there you got the beneficiary and all. With the corporation, you got stocks, and he's probably never issued any stock certificates. And if he dies, you got a mess.
So he's got to do a living trust.
Huh?
So you recommend him to do a living trust?
He could do a revocable living trust if he doesn't want to protect I would do a revocable living trust. I would put both properties into a revocable living trust, and right in there, whoever the successor trustees will give it to his kids. And that way you only have one, where if he's got two, he's going to have 2 land trusts. He could, if he's not worried about, damages on either one of them, he could put both properties into a land trust too. And that takes care of the beneficiaries and everything.
Okay. Now I have another And that's another question. What does, I know that you told me that the land trust costs between $500 and $600. What about a revocable living trust? What's the cost for that? And I'm
The
sure that a
total,
lot of attorneys are gonna kill us because I'm sure that your prices are much lower than everybody else, but it is what
the,
it is.
right, the package with a revocable living trust, a will, a healthcare surrogate, and also you usually need a quitclaim deed because you got to transfer the property into it and everything. For a single individual, it's typically right around $750. For a married couple, because I have to have two wills, two of everything, is $1,000.
Okay.
And I do.
I mean, it's not outrageous. I mean, we've
No.
heard, but I have heard of attorneys charging $5,000 to
Oh
do a
yeah,
revocable
that's the
living trust.
typical. About the lowest I see is, is 2,500, and it's usually between 2,500 and 5,000.
Yeah, so that's what
And
I said. I know that a lot of attorneys that are
right,
probably gonna watch because this is gonna go everywhere. They're probably gonna kill us. But so I have another question. Son in Florida gets power of attorney through the courts over mom. Mom didn't give him the power of
wait a
attorney.
minute, start over. What?
Okay, son in Florida gets
Right.
power of attorney through the courts over the mom. Mom did not give him power of attorney. Daughter in California had power of attorney that mom gave her years back. Is that legal? Can two people hold power of attorney over one person?
Wow.
What if the daughter never exercised the rights under the POA?
The courts don't give power of attorney.
The courts don't give power of attorney?
They appoint a guardian.
Maybe they appointed a guardian? No, she said
Yeah,
that they gave him a power of attorney. Maybe a guardian?
yeah, I think it's a guardian.
A guardian. They said that they gave him a power of attorney and she took over her assets, took over her apartment, took over everything, and just threw her in a home.
Right. Yeah, if he got a court order, that's going to be overruling that power of attorney she gave.
So that overrules the power of attorney that she gave him.
I'd have to, again, I need to see documents, because courts grant that you do guardianships. And the guardianship could give him power of attorney, of course. Right? A guardian, when you petition a court for guardianships, like the son could have petitioned the court to be a guardian of her person and her property, or you can do it guardian of her person. Okay, the person is you make medical decisions and all that. The property is you can sell the assets, you do whatever it is. That person and property is a powerful tool. That's what the power of attorney is. You're granting it to somebody. But typically, the court,
So with the power of attorney, that's what happens.
and it's through a guardianship.
Now, let me ask you something.
I would have to say the court, the one that's got the power of attorney, she should have known about the proceeding.
Right.
Being in that to show that she already had the power of attorney.
Okay, so the daughter should have gone and presented herself at court to exercise the power of attorney. Now, let's just say that if she would have had a living trust, none of that would have happened, right?
No, not necessarily.
Okay.
Yeah.
It just depends what exactly happens.
Power of attorney would take over the power of the trust. People are going to go into the court because they're not capable of making their own decisions again. As you get older, people start not making the wisest of decisions.
Right.
A great example is my mom. She's 96 years old. She's, very, very capable. She lives by herself in the house I was born in, on the farm, and we have somebody goes by and checks on her every day. But about a year and a half ago, I was there to see her, and my brother just found out she bought, according to this company, an extended warranty on her car, okay, for 5 years, all right, on a car that she drives probably 100 miles a month. That's a 1998, I think, Oldsmobile, all right. That's got probably about 130,000 miles on it. She got an extended warranty. The car at its best day might be worth $1,500. And they were charging her $6,000 for this extended warranty. And they had her check account. And she has no knowledge of it, doesn't remember it whatsoever. So, and they would not give my brother any information or whatever. So when I called him and I said, look, I said, you're either going to cancel this or I'll see you in court next week. And it was canceled in 5 minutes.
Wow.
But
well, yeah, you're the attorney.
right. But what I'm saying is these they've got so many, and that's the type of things when that happens, that's when people go into court to get control over that. Because if I had my brother, if I didn't have the power of attorney for him, I at that point I think she was still able, but that's when you have to go to court to get it. It's when they get elderly and they can't make decisions, and you can't get them to right because they don't know.
They don't know any better.
Right, they're not in a good frame of mind to give a power of attorney.
So I have another question here, Robert. What do you recommend if someone doesn't have any assets such as properties or business? I have 2 kids, bank accounts, life insurance. I want to make sure my kids are taken care of. Me and my partner have been together for 8 years, but are not married.
Wow. Get married.
No.
Yes,
Robert,
for
not
my
everybody wants to get married.
Yeah. Probably a simple will is fine, but the problem is that she can't make a decision for who's going to take care of her kids, because her kids, if she dies, her kids are going to be taken care of by the father.
Right.
He's
Right.
going to get that.
It would
And
only be both pass away.
Right. They couldn't do it, a will. What they need to do is they both need to do a will. And in the will, they need to agree on who would be the guardian of their children.
Okay.
She can leave all her assets to be held in trust. She doesn't need so much a trust account. She can leave her assets in the will, but she probably, it depends. It's hard to I would need to talk with them and find out exactly who in their family and things like that. Usually couples like this, one's sister or brother or something like that they agree upon, and you do it that way. But I would want them both to do separate wills or some type of, they could even do some kind of a joint trust or something if they could agree upon it.
And again, what does a will run a rough estimate about how much does that cost?
Oh, a will, so a simple will is like $250.
Yeah. Okay. That's not better. No. Okay, I have 3 more questions. I have my house as primary residence. I don't have any more assets. What is the best way that I could leave that to my children without them having to go to court?
Well, first would be the revocable living trust, and it could take care of a lot of different things. But the other thing she could do is, I don't like it as much, but when you only have one thing, she could put them on deed with her she could, if she only had the property, she could deed it with her having a life estate and them having the remainder. Okay. She could do that. And, you're just talking about like $100 to do a deed and to transfer it that way, where the trust would take care of everything and in the future too. But yeah, with just one property, what you can do is you can put them on the deed with you, either as a remainder interest with you, a life estate, or as joint tenants. The only thing there is the tax consequences, where if it's left to you in a will, there's no taxes. When I say no taxes, all right, I buy a property for $100,000. All right. I die 20 years later. The property's worth $400,000.
Also, the kids still have to pay for the taxes.
No, not if it's in a will. They get it. If at the day I die, it's worth $400,000. They get it. That's their basis is $400,000.
But if it's in a life estate?
No, the life estate with the remainder of them, I'm not positive. I'm not a tax attorney. But if they were joint tenants, their capital gains would be based off that $100,000.
Okay, so if it's in a life estate, the people that inherited, they will have to pay over that?
This is not inheritance tax. This is capital gains
Capital
tax.
gain taxes.
Like
Okay. So
anytime you
that's
buy a
something that we would
property
have
other
to
than
ask
your
the attorney.
residence,
I
if it's
mean,
your
the
home
accountant.
residence, you get a credits and all for it. But if you buy investment property and but the day you die and you leave it to somebody, they get it at that basis. It's called a stepped up basis.
Okay.
So that's the only danger in putting them on the title, because then they don't get the benefit of getting an up. The life estate might give them that also, though. I'm not,
Okay.
like I said, I'm not a tax attorney. I just know that the cost basis, you know, when you inherit something, it's you take it, you get the basis of whatever it is at the date of their death, not at the time they bought it.
Okay. All right. Okay. So I have a couple of properties, and I am foreign national with a visa, an investor's visa,
Right.
which I'm planning on renewing next year. What is the best way that I could do a will that it would cover my family as well as my properties, and also to protect it from liability? I think what you mentioned is the land trust, right?
Right. Yeah, I think the land trust, he's got what, a couple of properties?
Yes.
Yeah, I would do a land trust.
Now, foreign nationals can do land trust, I'm guessing, yes?
Of course.
Okay.
The one thing you have to be leery of in doing a revocable living trust, that would include everything here plus back home where he's from. And I
Oh,
wouldn't,
okay. I didn't know that.
yeah, but I wouldn't be familiar enough with what's critical back there. I don't know the laws of, like let's say they're from Venezuela or Peru or some other country. I don't know what those laws are. So they might already have, so they probably need some type of testamentary document that confirms with their country laws of if they've got property there. So the land trust would be better to take care of it here, and then it wouldn't have to be worried about their probate back in their old country.
Okay. Now I have another question. Are liabilities also inherited? Like, for example, if I owe $50,000 in credit cards or my student loans or anything like that, is that
Okay. In a trust, no way.
Okay.
In a probate, yes.
Well, that's another reason why people should do a
You don't have, exactly. If you, just like the lady I was telling you about that I had with the she's got a $1,700 credit card bill that we have to make a claim. That's a claim that's eventually got to be paid.
Because when you go to probate, you have to inform all the debtors also, right?
Oh yeah, you publicize, and any known debts you have to send them certified mail so that they can file a claim.
Okay, so but if I have a living trust, I don't have to do that.
You don't go to probate, you don't do anything. The
Okay,
only way you're liable for anybody else's debt is you signed on that credit card with them.
Okay, so now my question is, okay, so let's say that I only have $20,000 in assets, right? But I owe $70,000. What happens to that difference of $50,000?
Called risk. Whoever loaned you that $50,000 is out of luck. I guess that.
Okay, but my kids wouldn't have to take money out of their pocket to pay those $50,000.
I had a man that I knew from my church, and the pastor called me and said he'd been put in a hospice. All right. And so I went by Delray Medical, and he was still in the hospital room. And he had passed out, and he was terminal. And so he told me exactly how he wanted everything to be left. All right. I had no idea I knew he owned a home. That's all I knew. All right. I went back, it was about 4 o'clock in the afternoon. I went back, prepared it. I went in the next day. He died an hour before I got there. All right. He didn't want his sister to inherit anything. She got it all. No matter what I thought, what I prepared, anything like that. Because she was, he had no children. He had nothing. He wanted to go to his niece, his sister's daughter. Okay. And I think it was 2 in there, but it didn't matter. It went to it. And of course it was her mother. So it wasn't a great, but he had a falling out with his sister. He didn't want her to have a thing. Well, regardless, right? She came to me, and I did a probate proceeding, and I'm representing her because she got the. But he had roughly $35,000 worth of credit card debt. He was a hoarder. All right, we couldn't even hardly sell the house. You couldn't even walk through the house. So we sold the house. All right, but because it was his homestead. So I took it out of probate. I did a petition for homestead. All right. And she received all the monies from that because it was not a part of the, because homestead is not included. You have to do a petition to determine homestead. And once it is, that goes out. All right. His assets are still there. He had, and unbeknownst to me, I think he might have had maybe $800 or $1,000. But we sold everything out of the house. Somebody came by, auctioned it off and everything. She got that because it was just, what needed probate. But it was, I can't remember how much it was in credit cards, but it was $20,000, $30,000. Well, it was gone. Didn't matter. We notified everybody because we had to open an estate. It didn't matter. There's nothing to pay. All right. This was about 5, 6 years ago. A year ago, the lady, his sister, got notification that the state of Florida had roughly $4,200 that they had found that belonged to him. Some account we had no knowledge of or whatever. I think it was a refund back on his mortgage payments. All right. And so she came to me and says, look, can we go get this? I'm like, yeah, you can go get it. You open an estate. Guess what the first thing going to be paid? All those credit cards.
Yeah. So leave that money there.
Yeah. So,
okay. But I mean, if there's no money, like if I didn't leave money, okay, my kids they're not going to have to pay that. That was the most important thing. Now I have another question. I have two investment properties, one homestead property, all with more, two investment properties, one homestead property, all with mortgages. If I die tomorrow, what documents should I do to stop the mortgage company from going after the properties and instead have it go to my kids? You can't. I mean, unless you still have to pay the mortgage, right? Yeah.
Well, because they've got a lien on the property.
Right. So let's say my house.
That's the difference in the credit card debt. The credit card debt has no security. The house has security. So you can't sell that house. You can't do anything with it until you pay that whatever's owed to the mortgage.
That wouldn't be avoided even with the living trust. You still have to pay the mortgage company.
No. Yeah, they got a lien on that.
Yeah, like they would. But I guess the question is, they want to make sure that what happened to my client 2 years ago, which is the sister, didn't have the money to go to probate, the bank foreclosed and the bank sold it. There's nothing, if you don't leave anything for your family in writing, then the bank can do that. If your family does not have the money to go to probate, then the bank has the right to foreclose on the property, and then they have the right to sell it, and then they make the remaining money. So that's why it's so important.
No.
That's why.
No. All right.
No? Okay.
All right. Remember the one I just did for the guy that did the investment that came to sell and all that? All right. The bank, if they foreclose, they only get the monies that they're due. Okay. Whatever's left there would go to his heirs.
Okay.
Let's say you had a $100,000 mortgage. They got a judgment for $110,000 with all the costs and all that, and the property is worth $200,000. That $90,000 is surplus, and that would go to his beneficiaries.
But for example, what happened to my client is she never had the money to go to probate. So what happens to the $90,000 if I cannot go to the court and say those?
Petition to the court. The court's got the excess funds.
Okay, and then the money will go.
There's no probate in this.
Okay.
Okay,
I didn't know that.
To give you some examples that I've had clients come to me, and they're whoever died, they had a couple $1,000s in the bank. All right, no will, no nothing, and I tell them right there, it's like, I don't really want to earn that $2,000 because that's who's going to get the money. You're not going to get the money. It's going to cost you more to go get that money out of the bank account than what's in it. So if they don't, like with a trust, you got you got it automatically. Right. Like I've had people that didn't put one small bank account in the trust, and they say, "How do I get it?" You can't. You got to open a probate, and then you're opening up to everything. Now, the difference is if you paid the funeral expenses, all right, it might be worth it if it was $4,000 or $5,000, because funeral expenses would have a priority before the creditors.
Okay.
But still gonna probably cost you more than it's worth. It just, that's
Now,
why
another question that we have is, can the children continue to pay the mortgage? I guess
of
the mortgage
course.
company doesn't know that the person died unless you stop paying, right?
It doesn't matter. Anybody can pay the mortgage. Bank's not gonna refuse you money. They never have. Now, they will refuse it if you're kind of late and they want to foreclose. You're
Right.
90 days late, then you send them money, they might just send it back to you. But no, whoever, like in your will or in your trust, when I put it in there, the people that get the property, it's into your testamentary thing that they take the property subject to the liens and the mortgages on.
Okay. Okay. Well, I am gonna take one more question, and I think that's it, because we were supposed to do this for an hour, and it's already 4:15. So we've been at this for an hour and 15 minutes. I know
I talk too long.
it's not that you talk too long, it's that we had a lot of questions.
That's good.
But I know this is very informative, and for me, it was just very, very important to inform everybody. And nobody is doing this kind of webinars where
Right.
we're all talking about how we're going to invest right now, but we're not talking about how we're going to leave a legacy to our family and make sure that we don't leave them a burden. So last questions I'm going to take, and then you're going to give them your information, and then they can contact you, because I'm sure that a lot of people are going to want to do everything now. My husband died without a will and left a duplex property. Should we take care of his known debts before starting the probate or not? He has 4 kids.
I need probably a little bit more information, but he owns the duplexes outright.
The husband owned the duplex. Yeah, that we would have to ask them that.
Yeah.
Does he own the duplex outright? So let me wait a couple of minutes, see if they answer us. And is there a mortgage on the duplex? Are there any debts? I'm looking at the ASC, because
if they could
she's
give me
right here with
if they could give me kind of an estimate of how much equity is in the duplex.
Yeah, and an estimate of how much equity is in the duplex. Well, I hope you guys enjoy. I'm going to wait for her to answer that, so then we could ask her that. But in the meanwhile, Robert, give me your information, and how does everybody contact you?
The best way is the phone. It really is. My direct line is 561-706-7572. And when you call, I talk to everybody, so you really don't have to say, oh, I saw your webinar, or Paulina referred me. I like it when you tell me Paulina's referred me. She has a lot of people she refers me to. But if you use that when you call me, you can email me. My email is RLSHEARIN. That's my name. 1@yahoo.com. Don't forget the 1, because the other guy is Roger. And he sends me, he does forward them to me, even though I don't know him. He's been a nice guy. Don't forget the 1.
So I am so thankful, Robert, that we did this together. I've known you, like I said, for how long? 16 years, I think we've known each other. And, by far, I highly, highly recommend Robert. And I promise you, you don't even have to mention him that I sent you there, or that you saw him in the webinar, because I don't get anything from referring him clients. But he is.
I can't give money. I would. That's one of the things about the bar rules. They don't allow us to pay referral fees, which is kind of good.
But by far, he is the most honest attorney. He's the only, the most honest attorney I've ever met. And, he's taking care of my wills. He's taking care of a lawsuit from the pool that we're still dealing with that. Because
I did talk to I talked to the construction fund. Yesterday.
Are we gonna get any
they
money?
they got the claim. They said, well, it's just we got a lot right now.
I can imagine. But so he's and he's always available. He's always approachable. You can ask him any questions.
Yeah.
Maxine is asking me for you to please repeat your phone number.
561-706-7572.
All right, and repeat your email for me, please.
R as in Robert, L S as in Sam, Hearin, the number 1 at yahoo.com.
Still Yahoo, Robert? No more Gmail. At least you don't have Hotmail.
That's it.
Let me see. Oh, wait, she answered. Okay.
Okay.
What is the?
She just wrote yes, yes. I don't know yes to what.
Oh, no, but there's an open, estimada Constanza, espero que te encuentres bien. Te quería comentar
I
que...
have no idea.
Hold on a second.
My wife's fluid, but not me.
No, I don't know what that is. There's an open discussion here. Nah, I don't know what this one said. Okay. What she just said yes?
I asked her like 5 questions. She said yes, yes. I'm like, what?
Okay, so if
Repeat the question.
Well, the question was,
He owned a duplex with 4
yeah.
kids.
My husband died without a will and left the duplex property. Should we take care of his own debts before starting the probate or not? And you asked her, no. So do the probate.
Yeah, do not do, I mean, no, I would not, unless, the only way to, if you could get some kind of good settlement, let's just say you had a $5,000 credit card and they take $1,500. Yeah, I would do something like that, but don't pay off any full debt because it'll go right in a probate and you either negotiate them down or you pay them out of that. Because what'll happen here is a duplex will probably be, so he died without a will. He's got 4 kids and a wife, correct?
Yes.
And he didn't live there, right?
No, it's an investment property.
They don't want to sell it.
I gotta look
And they don't want to sell it. Oh, they don't want to sell it. So I guess keep paying the mortgage.
Yeah.
And the association.
Oh yeah, pay off anything to do with the house. Yeah.
Anything to do with the house. Yes.
The debts I was talking about is like outside the credit cards or anything like that.
Yeah, anything to do with the house. If they want to keep the house, to keep paying it, and then go to probate so the house can be transferred over to their name.
Right.
They live there? Okay, so keep paying the mortgage. Yeah. All right, Robert. Well, thank you so much again for everything.
Bye-bye.
It was so nice to see you, and I hope to give you a big hug soon.
Yeah.
Thank
Get
you,
on
and
your
thank
feet.
you. Yeah, I know, right? Look, I don't think anybody. Let me see if I can do the wear camera. So look, it's right here.
I can't believe it.
So
I think you were out partying. I don't believe it.
I really wish I had a really good story for how I broke my foot, but I don't. But
I cracked one bone. I was in my pool. I jumped up like this and I fractured a bone in my leg. I mean, how do you do that? I mean,
I don't even know. Mine was one step. One step.
All right,
Robert.
Bye-bye.
Thank you. Bye. Have a great day.
You too.